The EU AI Act Newsletter Number 65. Free Speech and National Plans. By Risto Ook. Subtitle: Ireland's Minister of State Dara Calleary has published a list of 9 national public authorities responsible for protecting fundamental rights under the EU AI Act. Heading: Legislative Process. Ireland publishes list of public authorities. Ireland's Minister of State Dara Calleary has published a list of 9 national public authorities responsible for protecting fundamental rights under the AI Act. These authorities will receive additional powers to perform their existing responsibilities when AI poses high risks to fundamental rights, including access to mandatory documentation from AI system developers and deployers. The named authorities include An Coimisiún Toghcháin, Meán, Data Protection Commission, Environmental Protection Agency, Financial Services and Pensions Ombudsman, Irish Human Rights and Equality Commission, Ombudsman, Ombudsman for Children and Ombudsman for the Defence Forces. The list fulfills Ireland's first obligation under the AI Act. Italy's approach to implementation. Luca Bertuzzi, senior AI correspondent at MLEX, reported that the Italian government has adopted a decree to assign its national digital and cybersecurity agencies to enforce the AI Act. Mario Nobile, head of the Agency for Digital Italy, emphasized that preparations began before this official assignment, with the agency building internal capacity and research partnerships. Nobile highlighted more than simply hiring staff. Developing complex competencies requires qualified personnel, continuous situation monitoring, and dialogue with scientists. The agency has collaborated with 14 Italian scientific professors and several leading universities on the national AI strategy. He stressed the importance of balancing the Act implementation with industrial strategy, given the lack of European unicorns and an AI champion. Regarding coordination among regulators, Nobile expressed confidence in the European AI Board as a platform for resolving differences. Overview of national implementation plans. Since the AI Act took effect on August 1st, member states have begun preparing for its implementation. The designation of national authorities is among the first priorities. This will be updated as new information becomes available. Please help us ensure this content is complete and accurate by sharing any information you have about the authorities with us. Heading: Analysis. There's an image here. Description. News article screenshot. The headline reads, "Safeguarding Freedom of Expression in the AI Era." Protecting freedom of expression. Jordi Calvet-Baidmont, Senior Research Fellow at the Future of Free Speech, wrote an op-ed in Tech Policy Press about the implications of systemic risks in the AI Act. The Act requires providers of high-impact general-purpose AI to assess and mitigate systemic risks, similar to the Digital Services Act's requirements for online platforms. While the Act is established, the upcoming General-Purpose AI Code of Practice offers an opportunity to protect freedom of expression. The Act's definition of systemic risk raises concerns about potential impacts on free speech, particularly regarding controversial content. Providers face challenges in balancing various fundamental rights and may tend towards over-removing content to avoid penalties. The European Commission's role as enforcer presents additional concerns, given the potential for political influence and the historical use of public security to justify speech restrictions. The DSA's implementation has already demonstrated these challenges, as evidenced by then-Commissioner Breton's controversial statements about platform shutdowns during riots in 2023. The case for comprehensive model evaluations. The think tank Pour Domain wrote a policy brief arguing that the AI Office's forthcoming codes of practice for general-purpose AI, GPI, model deployment should prioritize multifaceted evaluation approaches beyond black box testing. The recommendations include 1. Encourage, de facto, white box access for independent evaluators through custom APIs. 2. Facilitate access to contextual information for comprehensive audits. And 3. Implement multi-layered safeguards combining technical, physical, and legal measures. These recommendations aim to strengthen the EU's ability to assess and mitigate GPI model risks. The article emphasizes the importance of transparency, fairness, and robust evaluation methods. It also highlights the limitations of black box testing and advocates for various access levels, from black box to white box and outside-the-box evaluations, while suggesting mechanisms to minimize risks associated with comprehensive evaluations. Can the AI Act enforce fines better than GDPR? Tech Radar staff writer Ellen Jennings-Trace reported on a Dublin ISACA conference where Dr. Valerie Lyons discussed the AI Act's implementation in 2026. She suggests companies should not be overly anxious, noting similarities between the AI Act and GDPR's principles of transparency, security, and consent. Lyons highlighted issues with GDPR enforcement, revealing that less than 1% of fines have been collected in Ireland due to appeals processes. She noted that government agency fines ultimately cost taxpayers, citing Tesla's €75,000 fine as an example. For smaller businesses deploying AI systems, Lyons makes the following recommendations. 1. Conduct gap analysis using ISO or NIST standards. 2. Build on existing GDPR compliance. 3. Implement AI literacy training before February 2025. 4. Update ROPA notices, policies, and DPAs. And 5. Establish robust monitoring processes for AI systems. Why the Code of Practice matters. Nicholas Mose, the executive director at the Future Society, wrote an op-ed arguing why the Code of Practice for General-Purpose AI, GPI, matters. The code, effective from August 2, 2025, will detail rules for GPI products and services on the EU market. The code's significance for Europe includes promoting transparency and understanding about GPI models, balancing legal certainty with flexibility, and supporting responsible AI innovation. Globally, the code matters because it can establish a responsible approach to GPI development for non-EU companies, translate legislative obligations into practical measures and indicators, and serve as a blueprint for collaborative co-regulation. Submission on the establishment of the scientific panel. The Irish Council for Civil Liberties, ICL, has provided feedback on the draft Implementing Act for establishing an independent AI scientific panel. Their recommendations focus on 3 key areas. Regarding conflicts of interest, while the draft acknowledges experts must be independent and free from AI provider interests, ICCL suggests explicitly stating that conflicts of interest make candidates ineligible. On public transparency, ICCL recommends setting specific deadlines for the AI Office to process requests from the panel and publishing decisions and reasoning on a dedicated webpage. Concerning the effectiveness of the panel, ICL argues that trade secrets and business confidentiality should not impede the panel's work and suggests removing these references from relevant articles, noting that panel members are bound by professional secrecy. This newsletter was narrated by Type 3 Audio for the Future of Life Institute. It was first published on November 12, 2024. Images from this article are included in the podcast episode description. To report an issue or give feedback on this narration, go to t3a.is.